Hello. Hello and good morning to our esteemed dignitaries, faculty members and dear students. I, Anamika Baliram Joshi, student of BLS second year at Janardhan Bhagat Shikshan Prasarak Sanstha's Bhagubhai Changu Thakur College of Law welcomes our esteemed guests and everyone present here for today's fourth day of late Shri Janardhan Bhagat Memorial Lecture Series with Dr. Karuna Akshay Malviya, Director of D.Y. Patil Law School, Nerul. As we have already inaugurated the late Shri Janardhan Bhagat Memorial Lecture Series on 27th January 2024 with the great presence of Advocate Dilip Shinde Sir, Senior Advocate of Bombay High Court on topic Criminal Justice System in India. The second lecture was headed by Advocate Gajanan Chauhan Sir on the topic of bail application on 29 January 2024. And the third lecture was delivered by the Justice Pradeep Deshmukh Sir, former judge of Bombay High Court, on topic evaluation of evidence in criminal law on 13 January 2024. Before commencing with our program, with due respect, I would like to request you all to please stand up for the national anthem. Also, please be steady for the Maharashtra Git. पंजाब सिंध गुजरात मराठा द्रविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे भारत माता की जय. Please be still. Thank you, everyone. A lamp lightning marks the beginning of a journey towards brilliance and greatness. With this, as a mark of respect to our esteemed founders, late Shri Janardhan Bhagat Sahib, late Shri Changukana Thakur Sahib, late Matoshri Bhagobai Sanko Thakur, I would like to request our guest of honor, Dr. Karuna Akshay Malviya ma'am, and our principal, Mrs. Sanvi Deshmukh ma'am, to proceed to pay the flower tribute and light the lamp which symbolizes Thank you, ma'am. Now it's time to welcome our today's guest, Dr. Karuna Akshay Malviya ma'am. I may request to Principal ma'am to welcome ma'am with shawl, memento, and sapling as a token of respect and gratitude. Thank you, ma'am. Now, to enhance the work, contribution, and sacrifice of late Sri Janardhan Bhagat Sahib in the field of education, I would like to call upon the stage Ms. Purnima Bevle, student of BLS 4th year, to share a piece of verse from the book Karma Yogi with us.
शुभ दुपार, नमस्कार. जनार्दन भगत साहेब कोण होते हे मी त्यांच्या आयुष्यावर लिहिलेल्या कर्मयोगी या पुस्तकातून तुम्हाला सांगू इच्छिते. शेका पक्षाचे आमदार श्री विवेकानंद पाटील साहेब यांनी भगत साहेबांसोबत अनेक वर्ष कार्य केले. भगत साहेबांविषयी ते म्हणतात, 1979 साली मी व भगत साहेब जिल्हा परिषदेत निवडून गेलो. मी 1982 साली सभापती झालो. तेव्हा माझा अनुभव हा फक्त 1.5 वर्षाचा, पण त्यांचा अनुभव मात्र 25 वर्षाचा. तरी त्यांनी मला सभापती पदावर निवडून आणलं. नुसतं निवडून आणलं नाही तर माझी सभापती पदाची कारकीर्द यशस्वी कशी होईल याकडे सुरुवातीपासून लक्ष दिलं. व्यक्तीपेक्षा पक्ष मोठा नव्हे हे तत्व त्यांनी शेवटपर्यंत पाळलं. आपल्या मित्रांना, सहकार्यांना ते वारंवार सांगत. याच त्यांच्या आदर्शावर मी माझा राजकीय जीवनाचा पाया रचला. जनार्दन भगत हे माझे राजकीय क्षेत्रातले आदर्श आहेत. त्यांनी आपल्या राजकारणाच्या प्रचारासाठी बऱ्याच प्रकारे जनतेतील लोकांना समजवण्याचा प्रयत्न केला. लोकांना पटवून दिलं की आपल्यातील लोकच जर निवडून आली तरच आपली प्रगती होऊ शकते. त्याक्षणी आंदोलन भगतसाहेबांनी 1980 साली वाईयाडची स्थापना झाली. वाईयाडतील स्थानिक लोकांना रोजगार मिळायला हवा यासाठी मागणीसाठी आंदोलन केली गेली. त्याक्षणी गावातील लोक बायका पोरांसह रस्त्यावर असायची आणि या आंदोलनामध्ये भगतसाहेबांनी खूप जास्त सहकार्याचं कार्य केलं. या आंदोलनामध्ये त्यांनी शिडकोच्या अधिकाऱ्यांशी वाटाघाटी सुरू केली. शेतकऱ्यांच्या अडचणी शेतकऱ्यांच्या नेत्यांनी त्यांच्या समोर मांडल्या. जमिनी दिल्यानंतर शेतकऱ्यांचे काय, शिडकोच्या अधिकाऱ्यांना ते ठामपणे विचारत होते. हल्लीच्या काळात आधुनिक तंत्रज्ञान असल्यामुळे नोकऱ्या मिळणार नाहीत हे त्यांना समजावून सांगत होते. जमिनी ताब्यात देण्याआधीच तंत्रज्ञानाचं शिक्षण सर्वांना मिळालं पाहिजे. आणि त्यानंतरच जमिनी हस्तांतरण करून देऊ असे ते स्पष्टपणे सिडकोच्या अधिकाऱ्यांना सांगत होते. यातूनच 1975 आणि 76 साली उल्वा व उरण येथे IIT तंत्रज्ञान देणाऱ्या संस्था निर्माण झाल्या. यातूनच अनेक कामगारांना रोजगाराची संधी मिळाली. जेथे कामगारांना दिवसा 10 रुपये मजुरी दिली जात होती, तेथे आता 50 ते 55 रुपये मिळू लागली. हा काळ 1981 तो 72 सालचा होता. कदाचित त्या क्षणी कदाचित आता 50 ते 55 रुपये कमी वाटत असतील, पण तेव्हा मात्र 50 ते 55 रुपयाची खूप जास्त किंमत होती. तेव्हाचे मजूर आजही भगत साहेबांना देवासारखे मानतात. म्हणून म्हणतात ना, किती पदे हे आपत्काली, मुरुड सेवा ठाई ठाई, जातीसाठी मातीसाठी विध दुजला सर्वांसाठी. दत्तूशेठ पाटील शेका पक्षाचे माजी आमदार भगतसाहेबांविषयी म्हणतात, माझी आणि भगतसाहेबांची भेट 1956 साली झाली. विधानसभेची पहिली निवडणूक होणार होती. त्याकरिता आमची तयारी सुरू होती. तळोजे बावजे विभाग मी प्रचार कार्य करीत होतो, तर गव्हाण आणि ओवळे विभागामध्ये भगतसाहेबांनी प्रचार कार्य सुरू केले. त्या काळात निवडणुकी प्रचारासाठी कोणाला सांगितलं तर खरं वाटायचं नाही. सकाळी भाकरी करून भाकरी बांधून घरातून निघायचं. तर कोणत्या प्रकारचं वाहन नव्हतं, रस्तेही नव्हते. एखाद्या श्रीमंत माणसाकडे असली तर घोडागाडी असायची. रोज कमीत कमी 10 ते 15 किलोमीटरचा प्रवास व्हायचा. तरी देखील निवडणुकीच्या प्रचारासाठी ते एका गावावरून दुसऱ्या गावी जात होते. आपल्या विभागातील लोकांना अडचणींना सामोरे जावं लागतंय याची त्यांना खूप आतूनच तळमळ होती. म्हणून त्यांचे कार्य हे मोलाचे होते. भक्तांवर घरची देखील फार मोठी जबाबदारी होती. कुटुंब मोठं होतं. सर्व जबाबदारी पार पाडून ते समाजकार्य देखील करायचे. बेळगावच्या लढ्यात त्यांना 1 वर्षाची शिक्षा देखील झाली. पण आपण जे काही करत आहोत ते आपल्या बांधवांसाठी आहे हा विचार त्यांच्या मनात रुजला होता. त्यामुळे त्यांना जेल जरी भोगावी लागली तरी त्यांना कधी दुःख झालं नाही. म्हणून तर आभाळाएवढी ज्याची उंची त्यांनी थोडे खाली यावे, आभाळाएवढी ज्याची उंची त्यांनी थोडे खाली यावे, मातीत ज्यांचे जन्म मळले त्यांना उचलून वरती घ्यावे, त्यांना उचलून वरती घ्यावे. साहेबांचा जन्म ज्या मातीत झाला, ज्या मातीत मळला, त्या मातीतील समाज बांधवांचे आयुष्य मळले होते. त्यासाठी त्या बांधवांसाठी काहीतरी करायला पाहिजे, त्यांना वरती उचलून धरायला पाहिजे. म्हणून भगत साहेबांनी नेहमीच त्यांच्यासाठी मोलाचे कार्य केले. थँक्यू.
Thank you, Purnima. We are glad to have such eminent personality with us to share the knowledge on the topic victimology. Before that, I would like to give brief introduction about Dr. Karuna ma'am. Ma'am is continuously working in the law profession for more than a decade. Currently, ma'am serving as the Director, School of Law, T.Y. Patil, deemed to be University and hold PhD in Law, and also awarded Senior Research Fellowship from UGC. Ma'am successfully guided many PhD students and she is certified mediator also. Ma'am recognized for her prominent work in uplifting and improving the most sensitive sects of our society, that is women and children, and has been a part of the teaching profession of pre-law and law students. Ma'am presented papers at numerous national and international conferences, and her research papers published in various national and international journals also. And she is often invited as a resource person for the conference. Ma'am have also served as director for the Center Advanced Training Taxation Laws, Maharashtra National Law University of Mumbai, coordinator as the Center for Women, Law and Gender Justice at Maharashtra National Law University of Mumbai, HOD, Department of Research. Ma'am also served as a chairperson, Board of Examination. She is also a member of Academic Council, member of Board of Studies, and ma'am is also member of Anti-Sexual Harassment Committee, MNLU, Mumbai, external committee member of ICC, Sexual Harassment of Women at the Workplace at NIPSTR, Mumbai. She was also held as a principal at MGM Law College, Nerul, and many more positions. Under her principalship, she had given a platform for the development of students through unique programs, and she is a principal who is not only in Mumbai but in India who successfully executed the educational visit to the International Court of Justice, International Criminal Court, University of Oxford, Hague International Law Academy, Royal Court of Justice London, British Parliament of UK, and Criminal Court of England and Wales in February 2020 with 35 students. And also, her works towards society is appreciated by the member of Navi Mumbai. Now, I would like to invite Assistant Professor Dr. Kranti Bhogte ma'am to welcome our today's resource person.
I, Dr. Kranti Bhote, Assistant Professor, welcome you all to this enlightening session on the victimology, a very important topic in our social debate. Today marks the fourth day of JBSB annual lecture series. As you know, this year's lecture series theme resolves around the criminal justice system in India, shedding light on its various aspects. Each day, we delve into a specific aspect of the criminal justice system, aiming to provide a comprehensive understanding of its complexities and challenges. Today's lecture will continue this enlightful journey, focusing on yet another crucial dimension, that is victimology. Today we are honored to have with us the respected resource person, Dr. Karuna Akshay Malviya ma'am, Director of Dr. D.Y. Patil Law School, Nehru, whose deep expertise in this field promises to shed light on the conceptual analysis of victimology and its various aspects, especially in the Indian context. Students, your active participation and eagerness to learn contribute immensely to the success of this lecture series. We encourage you all to engage in discussion, ask questions, and share your perspectives to make the sessions more enriching for everyone. Thank you for being a part of JBSB commitment to fostering knowledge and understanding. Let's make today's lecture as vibrant and informative as the previous ones. So without further delay, let us extend a warm welcome to Dr. Karuna Akshay Malviya ma'am. We eagerly await the wealth of the knowledge and perspective she is about to share, which will undoubtedly contribute to our collective understanding of the victimology in India. Thank you very much.
Good afternoon to one and all present here. I could see a very disciplined crowd, and I'm really impressed the way Sanvi madam has taken over, and with due respect to our national anthem as well as due respect to our Maharashtra Geet, we are starting this program. So I am really impressed with the facilities you are giving to the students, the way you have arranged this lecture series. And I'm very lucky and fortunate to share an experience with you before I start with the session. Me and Sanvi slash Shubhangi has shared this other side during our college times. And we were together in college. And this is an example, rather, you should take it as a motivation that when you shared together memories, learning memories, fun memories, then when you enter a career, sharing a dais with her today is a fortunate occasion. And I really, congratulate Sanvi madam that she has given an apt justice to her post by motivating students. We all are sitting in a uniform. This is the first step which I take during all tenure of my academics to mold students, to make them understand the importance of black, white and black. Okay, because this is something which we are going to do forever for our life, and this boring color which people so-called say this is a boring color what you wear every time, black and white, but this is apt to our profession, that we are doing black ka white. Don't take it in otherwise. Black ka white is we are bringing people from darkness to the light, right? So I'm really happy. Congratulations. Now coming to the topic victimology. Since the theme of your lecture series is criminal justice system, it's very crucial and important topic. You will not understand it unless and until you will be given a field work to do the survey and research. Every one of you, rather when I'm in a D.Y. Patil School of Law as a director, we have our placement internship cell, and students come to us and they ask us, ma'am, we want placement in renowned companies, we want placement in renowned firms. Okay, I joined D.Y. Patil School of Law just 9 months back, and the first placement drive was organized, and everyone was behind those firms. Today, I could fetch very good firms on our panel, but also we have a collaboration with State Human Rights Commission, and I have sent 20 students on field for internship with them. When they went there, they understood those 20 students, and when they came back, and when the same question was put to them, what do you want to become after completing your law? And they are replying me, ma'am, we want to go in litigation. We want to go in litigation. We don't want to work in firm. When we are saying criminal justice system, we are the two limbs of the criminal justice system. We advocates, we will just not sit in one side and blame the legislations, the judiciary. We should become the instrument to enforce those legislations properly to get justice from the judicial system. In India, criminal justice system is very much neglected towards victim. If you see Indian Penal Code, Criminal Procedure Code, everything is developed in the line of penalizing or punishing the offenders. There are very less provisions for victims, or we do not have victim oriented approach. Have you seen? If you go back, you know IPC Indian Penal Code, if you see the sections, if you see the division of the groups, very less provisions are given for victims or the compensation provision for victims. Rather than when it is compensation, see these are two different and important terminologies, compensation and fine. Crime. What is crime or offense? Is an anti-social element. It is an anti-social activity. Correct? So we have to segregate first what is crime and what is civil wrong. When we are saying civil wrong, we don't say society at large. We say civil wrong is against individual. It's a personal remedy. We never say that civil wrong is against the society at large. But when we say crime, it's a society at large. Starting with the process, starting with the procedure itself, when an offense is committed, what we do? Do we approach civil court to file a suit? No. Or do we approach advocate to give a notice? No. When offense takes place, we run to the police station, right? And we try to file FIR, first information report, which is under section 154 on CRPC. Why we are going to police station? Because it is nomenclated that crime is anti-social and there is no personal remedy. You don't. Just say I'll tell you. If you go to ancient time, we have to go back to ancient time to understand it in a better manner. You must be having theories of punishments, right? So the first theory of punishment was retribution theory. The word retribution, it is derived from the Latin term retribure, that is to take revenge. Okay, because there was no system, there was no platform for giving reliefs to the the two disputant parties. What they were doing, they were fighting with each other. चोरी करिए क्या, चलो आप क्या करो, incapacitation of limb. Okay, eye for an eye principle, that was in retribution. So now system is in place. That's why we are not following those ancient ways of restitution. When I am talking about victimology, we are revolving into two things. What? Compensation and restitution. Now, when I'm saying compensation and fine, you understand that compensation is only given in civil wrongs. Then how are you going to compensate the victims of crime? Where is the resource? Where is the platform? So what Indian Penal Code is providing, you must have read it. Some year of imprisonment with fine, right? But where fine goes, whether fine goes directly to the victim, no. So it is an interface. There is a mediator. That is the system. That is a government. So this is what we have not yet evolved in the areas of victims. That still victims do not have access of monetary or pecuniary compensation directly for the which crimes, for the crimes like those who are crimes of victims. So this is a background. So this is a proposition. We have to understand the proposition before going to any of the research and then coming to the conclusion. So this is a proposition. I'll not say that this is a hypothetical proposition. This is a real proposition which we are facing in India. Now when I'm saying victimology, what is victimology? Is it a different science? Is it a different paper? No. Victimology is one of the branch of criminology. When I am saying criminology, what is a base? What is the base of it? It is understanding criminal law. So victimology, you will simply give a definition. Victimology is understanding victims of crimes. Is it so? Only we have to understand the victims of crimes. As I have accelerated your mind initially in the starting of this session, that everyone should be dedicated towards the victim approach of the society. And that's why what is a need? That we should accelerate our mind that yes, though I'll go to corporate firms, I want to earn money, everything. But 1% of my knowledge I will utilize for the society, for the litigation, for the rope of white and black. That is andhakar se prakash tak. Okay, so if you will follow this, you will really understand who are the victims. Every day, each and every one of us is victim of circumstances. Are we not? Maybe some of you are victim of circumstances even today, that you don't want to listen to the lecture, but you have to sit as a part of discipline. So it is a victim of circumstances. When I am talking about victimology, it is a branch of criminal law. It is very different. So we should not use those terms identically. Victimology is understanding who is a victim, understanding the need of criminal attention towards the rehabilitation, restitution of the victims. Understood? So victimology could be defined as a science of crimes and their victims, as it is a sub-discipline of criminology. So the very task of victimology is to make victim and offender a penal couple. What has to be made? Why we have to make it as a penal couple? Because we have to read, we have to understand the offense, the offender and the victim. We should not just rely, that's why we will come to the final part of this session when the judicial intervention has taken place and there is a judicial discretion wherein the compensation has been awarded by the judiciary to the victims. Why? Because in our legislation, there are no clear express, altitude or criteria for awarding compensation to the victim. And that's why there is a need that in India judiciary has interfered. So that's why we have to understand, we have to treat victims and crime and offender as a penal couple. Rather than now, under victimology, the victims are no longer a forgotten man. Now their status, now their identity is recognized. Now if criminology could in nutshell be described as a science of crime, that is the study of lawmaking, law-breaking and societal reaction to law-breaking. Victimology could similarly be defined as a science of crimes and their victims. Now, see, studies are not evolved suddenly, okay? Some of the research scholars, they take the propositions, they do research and then the study is evolved, right? So we should not forget about the fathers of victimology. Now, before going to fathers of victimology, and you are already going through the lectures of criminal justice system, I would like to hear from you Who is the father of criminology? You should know who is the father of criminology. Indian father of criminology. Forget about foreign. India. How many of you are intended to go to criminal practice, or who has a liking to criminal law? No one? Why you are in this series? No one? What do you want to do? Civil law? Property matters? Property matters? Yes? What do you want to do? Nothing. Yeah, it should be a dialogue rather than a monologue. Yes, what do you want to do? Just take a degree and get married? Then? Yes, what do you want to do? Yes. You only, second last. हाँ आप ही. Yes. What do you want to do after completion? Criminal law, na? Matlab, I understand. So every one of you, matlab your silence means every one of you want to do criminal law practice. So I take it as a, silence acceptance from you. So the father of criminology is Sutherland. Okay? Sutherland has given a multiple association theory. Now how crimes emerged, how criminals are conducting the criminal activity, what is the force which is making them commit the activity has been researched by many criminologists. Lombroso has given a theory of born criminals. Okay, so he thought that some misarrangement in the physical characteristics can be pinpointed, and that person can be a criminal. But the theory was reformed, evolved by modern criminologists, who's called as father of criminology, Sutherland. He gave a theory of multiple association theory, that one crime is not committed by one activity or one just a physical characteristic. There are multiple factors: geographical area, the person's attitude, the driving force, and so on. So he gave a theory of multiple association theory for understanding the criminologies and the driving force of commission of crime. Now when I am coming to victimology, Andrew Carman, who wrote a text on criminology entitled Crime Victims: An Introduction to Victimology in 1990. So 1990 is very advanced era, okay. Before that, in 1840 itself, the importance of victimology was realized in the society. And then there are two victimologists, Mendelssohn and von Henting, who propounded the theories on victims, like who gave what victims are or how victims should be segregated. So this Andrew has defined victimology as a study of victimization, victim-offender relationship, victim-criminal justice system relationship, victim and media, victim and cost of crime, and victim and social movements. When I am saying victim and media, what do you think, why it is given a nomenclature like this, victim and media? Many of the cases, for example, sexual offences, or some kind of cases where there is a possibility that एक case के कारण दूसरी हो सकती है, defamation हो सकता है, the identity of the victim is kept in suspicious, like it is not openly given, it is kept aside कि नहीं, identity क्या करना नहीं है, disclose नहीं करना है. So that's why the role of victim and media also plays into picture. Now, as I am saying, the father of victimology, Mendelssohn, he describes victim and offender as a penal couple. Now, at first, going back to the origin of criminology in 1880s, anything resembling victimology was simply the study of crimes from the perspective of the victims. Now, the scientific study of victimology can be traced back in 1940 and 1950s. So, two criminologists, who then was called as father of victimologies, Mendelssohn and von Henting, began to explore the field of victimology by creating typologies. What typologies means? Now, victims, if you want to understand, for example, for your studies also, if you want to understand any concept in a clear term, you will segregate it, right? For preparing a mood proposition, what we do? First, we read on the facts. Then we arrange it in a chronological order, right? So that's segregation. So that's why they decided that victimology should be oriented by the typologies of the victims. So they are considered as the fathers of victimology. Now these new victimologists began to study the behavior and vulnerabilities of the victim. Now for us, we say that only vulnerable section of society. Okay. So I welcome the honorable management members of this STEAM Institute, and I will continue with the session. So when I am talking about the typologies, okay, so victimology, according to the fathers of victimology, will be more in a better manner to be understood when it will be segregated in the typology. So this new victimology began to study the behavior and vulnerabilities of the victims. Now for us, when we say vulnerable section of society in India, we always say only woman and child, right? We only give a nomenclature to the vulnerability when it is in our mind that it is only woman and child. Why? Why victims only woman and child are vulnerable? As I am telling you that each and every day, every one of us is a victim of circumstances, a victim of situation. So it should not remain only to a particular section of the society. And accordingly, the typologies which are given by this Mendelssohn and von Henting, the first type was innocent. So they are not segregating it on the basis of gender or anything. They are saying innocent. So the first type of victim will be any innocent person. Other five types which are contributed somehow to their own injury and who represented victim perpetration. So those who are neglected, those who are contributing to the crime, okay. The other members, these are the other typologies which are elaborated by these two victimologists. Von Henting also propounded a victim of homicide and said that most likely type of victim is a depressive type who is easy target, careless and unsuspecting. For example, if a lady in a house always staying alone, okay, and it happens to be a notice to the other members around her, and she has a habit to, whenever she is in a kitchen, she will keep her hall ka door open so that anyone from the outside can easily access to it. Once it happened, twice it happened, thrice it happened. Now every time if it is the case, what will happen? She will be the victim of crime. Why? Because she is innocent, that she is feeling that everyone around me is very good, loyal to their own work, they will not come and do theft at my house. And she is a depressive type. Why depressive type? Because she is an easy victim. She is in her own room. Like when she is working in the kitchen, there is no one at her home. So these are the typologies which are propounded by these fathers of victimology. Now when again tracing back after the definitions given by these victimologists, tracing back to the definition and concept of victim, the concept of victim as it dates back to ancient culture of civilization, original meaning was rooted in the idea of sacrifice. Okay, that is execution of man or animal for the satisfaction of deity. So this was the original Vedic concept, that who are victims, who are prone to give a sacrifice to the deity. During the founding of victimology in 1940, victimologists such as Mendelssohn, von Henting and Wolfgang described victim as helpless dupes. Helpless dupes means who are easy to be duped, who are easy to be, जिसको easily फंसाया जा सकता है. So this was the advanced definition which was given by Mendelssohn and von Henting. Now, how victims participate in crime? Now, according to Von Henting, the first ever study of the role of victim in crime and found some general characteristics among them which are summarized like the poor and ignorant one and those who are greedy. So poor and ignorant can be understood, right? Poor and ignorant are always victim, but greedy, yes. So the study came out that those who are greedy, they try to fall themselves into problems because of their greediness, because of urging, easy money. So they can also become a part of victim. So they are a typology. Then victim of larceny. What is larceny? Theft or intoxicated or sleeping persons. Wanton or sensual, matlab wanton persons or sensual persons may also become a victim of situation. For example, easy. If a biker is coming from a side road, okay, and a biker in the in the mid evening asking a lady, I don't know the road, can you please guide me to the road? Now she is a sensual lady, okay, she's a sensitive lady. She goes ahead and she says, okay, I will sit on your bike and I will take you to the destination. Now what she has done? She has invited herself to become a victim. She has invited herself to become a victim of crime. So now you're understanding the aspects of victimology are not limited to woman child. The aspect of victimology are limited, or I think it's a wider aspect where the studies are already in place and we should pay due attention to it and we should make people as much as can aware for these things, because our laws are not making it official. The law documents which are there in our Indian Penal Code or CRPC, they are not victimology oriented. They are only offender oriented. We are only thinking about how to punish the offender. Okay, you punish the offender. That is there because he has committed crime. But see the other side. What victim is asking? What victim wants offender to be punished in which way? Why you are still punishing the offender in the traditional way? Take an example of solitary confinement, which is now discontinued. Okay, it talks about the Indian Penal Code has its clear mention why people were given in solitary confinement, because there is a hidden theory of punishment, which is a expiation theory. That is a prayashchit. So that was to make a person to keep in a solace so that a person can expiate on his deeds. And when he is given back in the society, he will try to commit crimes, less crimes. So his approach will be victims oriented. So in the expiation period, he will develop a thing. He will think about what he has done, how he has done, and how much he has troubled people around him, and he will not do that again. So that was the main purpose of introduction of this solitary confinement in our penal system. Now let's understand the current segregation of victims, like who can be prone to victims. Elderly person. Why elderly person? Now see, in Western countries, elderly person tend to be in lower income groups and have therefore needs special attention. See, in US, the problem of crime against elderly person is sufficiently serious to have drawn the attention of White House conference on aging held in 1973. So these factors may not be much relevant in traditional countries like India, where elderly people by and large live with their children. See, we are saying which elderly person will be the victims? Those who are staying alone. And that's why we are giving an example of US. In India, we call ourselves, we are not yet that modern. We are still traditional. We are still abiding. For example, a very live example which I happened to witness here today, that we played Maharashtra Geet, we played national anthem, that we are still attached to our roots. So we know that who has given us birth, we have to take care of them. And that's why in India, elderly people are not that prone to the group of victims. Why? Because their sons, daughters are there to take care of them or avoid them to get into any problems. Child victims. So this is a very sorry state in our country, that though we know that this kind of pedophilic activities or rapes against children are taking place in a rampant manner, and though we are so much aware, But still, if you see the data, if you see the NCRB data, the rate is going high and high rather than coming to a normal or coming to a deteriorating stage. So this is an identifiable group of victims, that is a child victim. Then victim of sex offences. Now victim of sex offences, the area has again taken another level of increase in this, because now not only females are victims of sex offence, but transgenders and even males are victims of sex offence. So again this particular area of victim needs attention. Female victims are definitely victims of sex offense, but there are other areas also of which females are victims. Can anyone of you tell me the areas of which the females are victims? Yes? Yes? Workplace, very nice. So in the year 2013, the Indian government has come up with the act, that is Prohibition of Sexual Harassment at Workplace. Before that, there was no act to protect women at the workplace. So this is a very good example which this girl has given. Workplace and domestic violence, family at large. Females are each other's enemy. So that's why the way the females are victims. Weaker section. Now, when I say weaker section, we always say weaker section is woman, child, or backward class. But when it is a crime, we should not limit our aspect only to these 3 points. Weaker section, for example, linguistic minorities. Now, if you go to Chennai and you talk in Hindi, they will not understand anything. They are so abide by their mother tongue. Only to some extent, yes, no, this, that, they know English. Otherwise, they know only South Indian, the language, Tamil language. So, in such places, when we go, we are a linguistic minority. And so, in such places, we are prone to become a victim of crimes. Anyone can mislead you, take you to any place, okay? So, weaker sections are, we should categorize it in religious and linguistic minorities, also ethnic minorities. Now, a number of caste and communal riots occur each year in a country. What happens when a riot takes place? What happens? Government just allot a fund for relief of a particular people involved in that mob. Whether government go and take a census of each and every home, so many of the victims get neglected. So the system is not that equipped today in India that each and every victim will get redress. Understood? The typologies which we have in our country. Now, how the compensation concept is there? Traditional and modern. If I say traditional, we all know the Latin maxim, ubi jus ibi remedium. Where there is a wrong, there is a remedy. So what is wrong? Now in tort we learn civil wrong. Okay, so that's why I told you in early session itself that we are saying compensation which is only limited to civil wrongs. The compensation cannot be given to crime victims. So that is something fine which goes to the government, and then government gives a quantum of that amount to the victim. So still, when I am saying victim and offender has to be read as a penal couple, let them both be together, let them settle their own thing. Though the problem offence is settled by the government, but when it is a monetary, pecuniary, let them settle by themselves. But in our India, in our country, it is still a dream to be achieved that the compensation will directly go to the victim. In India, in Criminal Procedure Code, we have a provision under section 357, through which we are having the compensation provision to the compensation to the crime victims. Okay, so it says that whenever a criminal court imposes a fine, a court may order the whole or any part of the fine recovered to be applied in the payment of any person to be a compensation. So again, it's a discretion of the court to give a quantum or a full amount of fine as a compensation to the victim. We'll just take an overview of some of the judgments. Okay, in Sarwan Singh versus State of Punjab in the year 1978, it was said by the court that in awarding compensation, the court should just consider what compensation ought to be awarded to the heirs of the deceased and then impose fine which is higher than the compensation. So the court laid down that the amount of fine should be determined on the basis of various factors including the nature of crime, number of injuries and paying capacity of the offender. So this criteria is given in the year 1978, the criteria to award the compensation. The compensation amount, which is a fine amount which is recovered from the offender in the court of law, should give a consideration to all these factors. In Muhammad Shah versus Emperor, this is a very old case, 1934, the offender was awarded 1 year imprisonment and a fine of rupees 500. Okay, out of rupees 400 was awarded to the heirs of victim. So the judicial attitude is, however, reflected somewhat differently in Guru Swami versus State of Tamil Nadu in the year 1979. It was held that in the case of murder, it is only fair that proper compensation should be awarded to the dependent of the deceased. And perusal of a subsequent case, Baldev Singh versus State of Punjab in the year 1995 also indicate that quite often Supreme Court prefers to substitute severe punishment given to the offender in award of compensation to the victim in death resulting due to family feud. Okay, so see again, this is all a matter of judicial discretion. Why? Because we do not have a strong legislature. We do not have a separate legislature for the victims of crime. Only one section, 357, is talking about victim of crime and which is very beautifully saying that quantum of the fine or full fine at the discretion of the court. So lately what happened? I think you all are aware about this act. The Probation of Offender Act came into force in 1958. The Motor Vehicle Act came into force in 1939. The Fatal Accident Act 1955. The Indian Railways Act 1890. Workmen Compensation Act 1923. And the very tool of the Constitution, the soul of the Constitution, Article 21 of the Constitution. So these all, provisions in the land of our country, they amplified, they glorified the compensation schemes to the victim. Supreme Court, you all must be knowing this case. Supreme Court has expanded Article 20 word and incorporated a new branch of a study from Rudal Shah case, okay. Chandrima Das, wherein the Supreme Court evolved the victim compensation scheme. Although it has been criticized by various scholars in the name of unbranded expansion of life and personal liberty. When I am talking about Rudal Shah versus State of Bihar in 1983, what was the facts? Like what happened? That a person was under trial and he was detained for a long period of 14 years without given opportunity to be heard. And when it was realized, when it was understood, he was given a compensation by the Supreme Court of rupees 30,000. The victim was languished in the jail for 14 years after his acquittal due to irresponsible behavior of the state officers. Then in the case of Saheli versus Commissioner of Police in the year 1990, the mother of a deceased son who was 9 years old was awarded a compensation of 75,000 rupees when the deceased was snatched from the mother and thrown on the ground by a police constable and the deceased died due to it. This is a part of police atrocity. Then Nilavati Behra versus State of Orissa in the year 1994, the Supreme Court awarded a compensation of rupees 1,50,000 to the mother of deceased again who died because of police beating. Now see again, we are just seeing the judicial discretions for the violations of state officers or for violations of the police officers. But what about each and everyday violations of the normal citizens who are victims? Those are not even reaching to the courts, right? Then Kelavpati versus State of UP, 1995. The widow and the children of a convict killed in jail by a co-convict, was awarded a compensation of rupees 1 lakh because of deprivation of right to life under Article 21 of the Constitution as the jail authorities failed to protect his life. And then in the year 1996, Bodhisattva Gautam versus Shubha Chakraborty, the Supreme Court awarded interim compensation of rupees 2000 per month. Now see, this provision is nowhere in any legislation. That till the case or till the case has been decided or till the offence has been finalized under trial, interim compensation 2000 per month. It's a kind of judicial discretion only. To the victim till the criminal charges were decided against her teacher, who not only induced her to cohabit with him but went to a certain marriage ceremony before the god whom he worshipped and put vermilion on her forehead, giving her belief that she had become her lawful wedded wife. Now this is 1996. A child has been duped by a teacher through a mock marriage process. Tell me, if it had happened today, is there any legislation to protect a child? Is there a legislation? It is there, no? POCSO, Protection of Child from Sexual Offences Act 2012. So that legislation was not there then. That's why the judiciary had to intervene and give the interim relief to the victim by way of compensation. So this is how beautifully the victimology and the theories of victimology and the need of an hour. Now see, you people with such a dynamic principle of yours can take ahead, definitely your management body, they are so supportive, they will, I think you should take projects in hand. We are already a collaborative partner with your school, sir. We can take projects in hand, we can involve your students in the live activities, we can give them platform, and you will really understand what victims are and how the support is needed. You know what? We recently organized the paralegal volunteer training at our university, and I think your principal will very soon organize it for you. So the paralegal volunteers is kind of tool to the society. Before becoming advocate, you are getting a knowledge or authority where you can go and ask the police, you can go and ask authorities, you can go and ask in the jails also that why this is so. Definitely you should have that card which will be given by district legal aid authority. So the program will be organized in collaboration and you will be involved. So this is something appeal I want to make for victimology so that they can better understand it in a practical way. Okay. I hope you have experienced my particular session in a nice manner. You have taken some input. If you have any doubts, you can ask me. Yes, you can ask me. पूछिए. Any doubts? Yes. Okay. Hello. 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 Yeah. Very nice question. So that you are very much attentive for this session. So you have heard about 320 section of CRPC compoundable offences. So we have a list of offences which come under compounding, right? So offences can also be compounded. So you know where there are provisions, we should take benefit of it. I'm not saying to compound the offence of rape. I'm not saying to compound the offence of murder, but where it is possible. Penal couple is not only for satisfaction of the compensation. Penal couple, it should be called to understand the quantum of injury which has been experienced by that victim. So when they both are together, when they are read as together as a couple, then we will understand that what kind of relief that victim is needed. Understood? So in that way, I am not saying Mendelssohn has said it, that he is a victimologist, that the victimology should be understood in a way when they will read as a penal couple. Right? Any more questions? That's it? Yeah. So I again thanks the management and your respected principal, Mrs. Sanvi Deshmukh, for giving me opportunity to interact with you all. And I appeal to all of you, as we are a collaborative partner, whenever there are sessions taking place at our campus, please do come and please take as much as certificates you can collect in your tenure as a student. Thank you so much.
Thank you, ma'am, for sharing your knowledge and words of wisdom. It was really a great honor for all of us present here to get an opportunity to become part of your lecture. Thank you, ma'am. Now we are welcoming our esteemed dignitaries, Honorable Sri Ramshed Thakur Sir, Chairman of JBSP Sanstha, Panvel. I would request Principal Ma'am to welcome our guests with shawl and sapling. And also welcome Honorable Sri Y.T. Deshmukh Sir, Vice Chairman of JBSP Sanstha, Panvel. Now I would request Ramshed Thakur Sir to address our audience.
आपल्या जनार्दन भगत शिक्षण प्रसारक संस्थेच्या भागवाई चांगू ठाकूर कॉलेज ऑफ लॉ या कॉलेजमध्ये आपण 27 जानेवारी ते 2 फेब्रुवारी या कालावधीमध्ये लेट श्री जनार्दन भगत मेमोरियल लेक्चर सिरीज ठेवलेली आहे आणि त्यानिमित्तानं आज आपण या लेक्चर सिरीजमध्ये माननीय डॉक्टर करुणा मालवीय, डायरेक्टर ऑफ डॉक्टर D.Y. पाटील लॉ स्कूल नेरूळ यांना प्रमुख वक्त्या म्हणून तो बोलवण्यात आलेला आहे. त्यांचं आपण सर्वांनी स्वागत केलं. मी पुन्हा एकदा स्वागत करतो. या कार्यक्रमाला उपस्थित असलेले या अगोदर आपल्या याच्यामध्ये सिरीजमध्ये सहभागी झाले होते आणि आजही माझ्याबरोबर झालेले आहेत ते आपल्या संस्थेचे व्हाईस चेअरमन Y.T. देशमुख, प्रिन्सिपॉल देशमुख मॅडम, 3 मिनिस्टर झाले हे 2 अंक अगोदर गेलेले आणि माननीय मॅडम. तर त्याचबरोबर प्रिन्सिपॉल आणि सर्व माननीय स्टाफ, सर्व लॉचे विद्यार्थिनी बंधू आणि खरं तर मी आज अचानकच तुमच्यामध्ये आलो, कारण परवा मी त्या दिवशी आपल्याला गजानन सावंत लेक्चर झालं तिथे पालिका प्रशासनावर ऐकलं आणि ते फार छान वाटलं मला. ह्या पद्धतीनं आपल्या लॉ कॉलेजमध्ये जे काही प्रोग्राम होत आहेत हे अतिशय चांगले असे प्रोग्राम आहेत. अर्थात मला एकच ऐकायला मिळालं, आपण इथं देशमुख मॅडमने आपल्याकडं प्रत्येक दिवशी एक वक्ता अशा प्रकारे जवळजवळ 6-7 वक्ते आपण इथं ठेवलेले आहेत. आणि ही लेक्चरची सिरियल जी आहे ती आपण इथे ठेवण्यात आलेली आहे. जनार्दन भक्तांची जयंती ही 4 वर्षांनी एकदा येते. पण त्यांचा जन्म 29 फेब्रुवारीला झाला आणि 29 फेब्रुवारी हा लीप इयर जे आहे ते लीप वर्ष दरवर्षी काही येत नाही. त्याच्यामुळं जर 100 वर्षात फक्त 25 जयंती साजरी होणार. त्यामुळे आता ही जयंती जी आपली 96वी जयंती आहे आणि 24वा जन्मदिवस आपण साजरा करतोय. नंतरच्या काळात सुरुवातीला दरवर्षी झाला असेल ते 58 वर्षापर्यंत जगले आणि 58च्या नंतर दर 4 वर्षांनी आणि त्याच्या अगोदर सुद्धा जयंती त्यांचा जन्मदिवस 29 तारखेला 4 वर्ष उजाडत होते. तर अशा 24 चोक 96 त्याचा फक्त 24 जी जयंती जे वाढदिवस अगोदरचे झालेले ते त्यांचे आलेले आहेत. आणि जनार्दन भक्तांच्या बाबतीतली माहिती मला ती मॅडमला पण आपल्या स्कूलवर जाऊन सांगितले असेल. तुम्हाला या सर्व विद्यार्थ्यांना माहीत झालं असेल. खरं तर जनार्दन भगत साहेबांकरता फोटो आपण पाहतो, पण फोटो पाहिल्यानंतर ही व्यक्ती कोण हे बऱ्याचशा तुम्हाला स्टुडंट्सना माहीत नसतात. आता मला विद्यार्थी तुम्हाला जरा लहान वाटतं, स्टुडंट्स म्हटलं की बरं वाटते ना. सध्याला विद्यार्थी म्हटलं की हायस्कूलचे विद्यार्थी असं वाटतं. तसं नाही, विद्यार्थी हा जन्माला आल्यापासून तो विद्यार्थी असतो आणि वरती जाईपर्यंत विद्यार्थी असतो. जन्माला आलं की ते मूल काही शिकायला लागतं. आईच्याकडनं, शेजारी पाहिजे, वडिलांकडनं, घरच्याकडून चालावं कसं, बोलावं कसं, म्हणजे आई कुणाला म्हणायचं, मम्मी कुणाला म्हणायचं, या सगळ्या गोष्टी तिथून शिकायला लागतो. आणि किती जरी आता मी 73 वर्षात झालो, आमचे मित्र 73 इयर्स झालो, पण शिक्षणातलं त्यातलं एक कण पण आपण शिकलो नाही. जगात इतकं ज्ञान आहे की ते ज्ञान जे आहे ते अफाट ज्ञान, आकाशाच्या पेक्षा त्याला आकाशाला पण गवस नाही असेल, पण ज्ञानाला गवस नाही अशा प्रकारचं इतक्या मोठ्या प्रमाणात ज्ञान आहे. आणि माणसानं आपल्या आयुष्यात जास्तीत जास्त हे ज्ञान ग्रहण करण्याचं काम करायला पाहिजे आहे. जितकं आपण ज्ञान घेऊ तितके आपण मोठे होऊ. शरीराला फुगणार नाही, पण आपली उंची जी आहे ना तितकी वाढणार आहे. दिसणार नाही पण ती उंची वाढणार आहे. आणि तुमचं क्षेत्र जे आहे लॉ मधलं हे तर अफाट आहे. आता मॅडमने उदाहरण देताना आपल्याला US मधलं किंवा आणखीन कुठलं तरी बरीचशी उदाहरणं दिली. म्हणजे आपण आता भारतीय ते भारतापुरते राहिलेले नाही. आत्ताच मगाशी येताना मी 11 वाजता TV लावला आणि आपल्या राष्ट्रपती मॅडम जे आहेत त्यांनी भारताच्या संसदेमध्ये त्यांचं अभिभाषण केलं. या पार्लमेंटच्या त्यांच्या अधिवेशनाला सुरुवात करताना त्यांचं भाषण करण्यात झालं. भारताच्या पद्धतीत या वर्षभरामध्ये या कालावधीमध्ये अगोदरपासून घेतले निर्णय भरपूर, पण किती निर्णय झाले आणि कशा त्यांना प्रगती केली तर त्यांच्या 10 वर्षाच्या काळात काय झालं हे ते सांगत होते. त्या बोलत होत्या आणि प्रत्येक वाक्याला सर्व खासदार प्राईम मिनिस्टर पासून जे प्राईम मिनिस्टर समोरच बसलेले होते, गृहमंत्री समोरच बसलेले होते. स्टेजवर फक्त कोण होते? फक्त राष्ट्रपती मॅडम होते. तशा त्या मॅडम फक्त एकट्या बोलत होत्या. तशा त्या पार्लमेंटमध्ये सुद्धा नवीन पार्लमेंट झालं तर मी अजून बघायला गेलो नाही. फार इच्छा आता जावं लवकर असं जाणार आहे. मी 6 वर्ष त्या पार्लमेंटने काढली 98 ते 2004 पर्यंत. त्यावरती पार्लमेंट सदन वेगळं होतं आणि त्याच्यानंतर आता हे नवीन मानलंय त्यातलं आता सुरू झालेलं आहे. तशा हे कॉलेज पूर्वी आपलं कॉलेज होतं, आता फरक पडतोय ना बिल्डिंगमध्ये बसायची व्यवस्था आणि सर्व एकदा पाहायला गेलं फ्रेश वाटतं. आता बरं वाटतं. तुम्ही काम वगैरे झालं होतं, ठकठोक आवाज सगळं होत होता आणि आपल्याला काही समजत नव्हतं. अशा विविध कायदे जे केले त्या कायद्यांचं बराचसा उहापोह सुद्धा तर केला जात होता. या नजीकच्या काळामध्ये कशा तरी कायद्यामध्ये 370चा कायदा असेल किंवा आणखी इतर कायदे असतील म्हणजे 3 तलाक म्हणतो ना आपण, ते असतील. त्याचा उल्लेख त्या मॅडमने पण केला. वर्ष, 5 वर्ष, 10 वर्ष नव्हे तर शतकावधी वर्षे सुद्धा ह्याचा उल्लेख केला जाईल. शेवटी मानवाच्या जन्मापासून जशी प्रगती होती तशा त्यानं कायदे बदलत गेले. ते लेखीच असतील अशातला भाग नाही. रूल्स जे आहेत ते प्रगतीचे आहेत, ते लेखीच असलेले भाग नाही. पण त्याचा सगळ्याचा अभ्यास तुम्ही इथे करता. आत्ताच्या जगात जगत असताना आपल्याला काय पाळायला पाहिजे, कशात त्याने वागायला पाहिजे, आणि त्याच्याबरोबर कुणी चूक केली काय तर त्याला पनिशमेंट काय, कशाने द्यायची, आपला अधिकार काय, कर्तव्य काय, या सगळ्या बाबतीतली माहिती जी आहे तुम्हाला देते. मी मॅडमचं, आपल्या देशमुख मॅडमचं मुद्दाम अभिनंदन करेन. त्यांनी ही चांगली सिरियल ज्या भाषणांची जी आहे तिथं आयोजित करण्यात आलेलं आहे. पण मला बरं वाटलं, हे पाहिल्यानंतर छान प्रिंट केलेलं आहे, नावं, फोटो विटो सर्व म्हटलं चांगलं आहे. म्हणजे आता अशा प्रकारचं काम पाहायला आपल्याला पाहिजे आहे, आणि ते काम अशा पद्धतीने केलं आहे. ह्या याच्यामध्ये संस्थेच्या बाबतीतलं माहिती आहे, भगत साहेबांच्या बाबतीतली माहिती आहे. तर याच्यामध्ये त्यांनी म्हटलं संस्था म्हणजे काय, संस्था काय आहे, त्यानंतर भगत कोण होते, त्याच्यानंतर विजन आपलं काय आहे, ऑब्जेक्टिव्ह काय आहे, सगळं व्यवस्थित लिहिलंय. आणि त्याच्यावर ते माहिती पण दिली, आणि कोणकोणती येतात ही माहिती दिली. विद्यार्थी मित्रांनो, आपल्याला एक गोष्ट हे घ्यायचं आहे, आयुष्यात आपल्याला शिस्त शिकायची आहे. आणि बेशिस्त चाललं असेल तर त्याला पनिशमेंट पण मिळाली पाहिजे. आणि तशा आपल्याला कशात जावं लागेल, वागावं लागेल. कधी मऊ व्हावं लागेल, कधी कडक व्हावं लागेल. अशा प्रकारे आपल्याला जर आपण ज्या पोस्टवर आहोत ना त्या पोस्टचं आपल्याला मान राखायला पाहिजे आहे, आणि त्याच्याप्रमाणे आपलं कर्तव्य आपण निभावायला पाहिजे आहे. विद्यार्थी मित्रांनो, आता तुमचं काम जे आहे ते शिकायचं आहे, समजून घ्यायचं आहे, जाणून घ्यायचं आहे. तर तुम्ही शंका फार कमी विचारल्या. मी मॅडमला आभार मानेन, तुम्ही इतकं सांगितलं की त्यांना सगळं समजलेलं आहे. त्यामुळे त्या मला शंकाच राहिली नाही. तुम्ही जे काही सांगितलं हे सर्व तुम्हाला समजलंय, आणि तशा पद्धतीनं मग आपल्याला साधारणतः आयुष्यात वागताना आता तुम्ही त्यांनी विचारलं आणखी काय शंका, तुम्ही काय बोलायला तयार नव्हता. पण एकंदरीत त्या सिरियलमधून तुम्ही भरपूर शिकले असणार. बोलण्यासारखं भरपूर आपला तो विषय नाही आहे, आणि भाषण देण्याची स्टेज नव्हे, त्यांनी मुद्दाम ऐकायला आलो होतो. आणि चांगल्या अर्थाने सिरियल तुम्ही आयोजित केलेले आहेत. मॅडमना आणि तुम्हाला सर्वांना धन्यवाद देतो. अशाच प्रकारचे विविध प्रोग्राम आपल्याकडे घ्यावेत. आपल्या मॅनेजमेंटवर तुम्हाला पूर्ण सपोर्ट राहील, आणि विद्यार्थी मित्रांनो जास्तीत जास्त सहभागी व्हा. आपल्या शंका तुम्हाला समजली नसतील तर जरूर विचारा, माईक घ्यायला लागू नका. माईकच्या वरती आपल्याला बोलायला पाहिजे, सांगायला पाहिजे. आपण सांगू तर समजणार आहे, आणि उगाच गेलो तर न आपल्याला वर्गात बसलो आणि गेलो तर आपलं ज्ञान जास्त वाढणार नाही. आताच्या शिकवण्याच्या पद्धती बदलल्या, प्रश्नोत्तराच्या रूपाने शिकवलेलं जास्त समजतं. त्याच्यातून साधारणतः जे आहे ना, पूर्वी आता प्रश्नोत्तर उदाहरण लहान मुलांना काय त्या वस्तू दाखवा, हे करा, ते करा, असं दाखवा लागतं. तिथे तुम्हाला त्याची गरज नाही. तुम्ही जगताय, अनुभवताय. तुमचं अनुभव विश्व हे मोठं करण्याकरता मॅडम आल्या, तुम्हाला वाचन केलं, त्यांना मी धन्यवाद देतो. आणि भावी काळामध्ये भगुबाई ठाकूर लॉ कॉलेजचे विद्यार्थी मोठे लॉयर, अगदी सगळीकडे हायकोर्ट, सुप्रीम कोर्टला दिसतील, न्यायाधीश होतील, अशी अपेक्षा व्यक्त करून थांबतो.
Thank you, sir, for addressing our audience. Now, as we are towards the end of the fourth day of the lecture, I would like to invite our principal, Mrs. Sanvi Deshmukh ma'am, to address the audience and share her thoughts.
Thank you very much. Respected Chairman, Lokanete, Shri Honorable Shri Ramjit Thakur sir, Vice Chairman Y.T. Deshmukh sir, Director of D.Y. Patil School of Law, Dr. Karuna Malviya madam, my fellow colleagues and my dear students. Here we are coming to an end of the fourth day of Janardhan Bhagat lecture series. Here, sir, मला सांगायला फार आवडेल, आपण ही लेक्चर सिरीज YouTube लाईव्ह वरती करून सगळ्या बाकीच्या लॉ कॉलेजेसच्या स्टुडंट पर्यंत पण पोहोचलेलो आहोत, ज्याच्यामध्ये आपल्याला सर जम्मू काश्मीर, नागपूर, अकोला, औरंगाबाद, जवळजवळ देशातल्या बऱ्याच कानाकोपऱ्यातून रिस्पॉन्सेस आलेले आहेत. लोकांनी समोरून सांगितलेलं आहे. लोक रोज आपली लेक्चर सिरीज ऑनलाईन ऐकतायत आणि त्यांना ते सगळ्यांना खूप आवडतंय. सो हिअर आय वुड लाईक टू टेक दिस अपॉर्च्युनिटी टू थँक आवर मॅनेजमेंट. सर, तुमच्यामुळे आम्हाला हे करणं शक्य झालं आणि देशाच्या कानाकोपऱ्यात पोहोचणं शक्य झालं. थँक्यू सर. टॉकिंग अबाउट टुडेज लेक्चर, आजचा विषय होता आपला विक्टिमॉलॉजी. Victimology, when we were talking about criminal justice system in India, when we were discussing about what is to be happened with the criminals, how to curb the criminal activities, and how to have peaceful society, for that government of India is taking action from time to time. But at the same time, there is one angle which needs to be taken care of, that is of victim. The victim needs to be taken care of properly, because as we all know that punishment द्यायला तुम्हाला वर्षानुवर्ष लागतात, पण त्या victimला तो तुम्हाला कुठेतरी एके ठिकाणी ती तुमची जन्मठेप होते, 3 वर्ष, 7 वर्ष, 14 वर्ष तिथे संपून जाते, पण तो victim साठी तो त्याची आयुष्यभराची मेमरी होऊन जाते. म्हणून त्यांना आपल्याला वेळोवेळी कॉम्पेन्सेशन देणं, वेळोवेळी आधार देणं, त्यांच्यासाठी एक सिस्टीम बनवलेली आहे, दॅट इज विक्टिमॉलॉजी. सो आय फील वेन वी आर टॉकिंग अबाउट क्रिमिनल जस्टिस सिस्टम, the theme will be incomplete without victimology. And I'm sure you all have understood. Madam had tried her level best to reach to all the aspects of it. Again, victimology is a very vast subject, wherein it is not possible to cover that in a session. But I congratulate Madam that Madam, you have touched and fulfilled all the angles of victimology. Thank you very much, Madam. So thank you very much once again to everyone for attending this session. We look forward for tomorrow and day after session. Okay, thank you.
Thank you, ma'am. As we conclude this event, I invite Sukanya Jadhav, student of 3rd year BLS, for express our gratitude and deliver vote of thanks.
Thank you, Anamika. A very good afternoon to one and all present here. I am Ms. Sukanya, student of 3rd year BLS LLB. On behalf of जनार्दन भगत शिक्षण प्रसारक संस्था, भागुबाई चंगू ठाकुर College of Law, and the faculty members, as we being curtained down on the 4th day of this session, I extend my sincere gratitude to the Janardhan Bhagat Shikshan Prasarak Sanstha to give us opportunity to Thank you so much.
As we all know that gratitude is the language of heart to show appreciation towards the person, but these words will be less for today's guest, Honorable Sir Chairman of JBSP Sanstha, Ramjan Thakur Sir, and Vice Chairman YT Deshmukh Sir. On behalf of my institution, I extend my heartfelt appreciation to Chief Guest, Honorable Dr. Karuna Ma'am, the Director of JBSPS-Panvel College, who has spared her time from her busy schedule to grace the event. Today, we had an opportunity to hear your thoughtful session, ma'am, and this insight gained during this session will serve as a beacon for future endeavors. A special mention to our respected principal, Mr. Sanvi Deshmukh ma'am, for being the catalyst and stimulated to do our best for today's program. An event like this cannot happen overnight. The wheel started rolling weeks ago. It requires planning and a bird's eye for details. With a deep sense of appreciation, we thank all our beloved and respectful professors and non-teaching staff. I would also like to thank the people who work behind the scenes. Because of their efforts made this event possible and successful. Last but not the least, big thank you to each of you to be disciplined and a good listener. Thank you. Before concluding today's session, I request everyone please stand for